right to be forgotten, a right of individuals to request data providers to have their data completely deleted from their services, has recently made a lot of headlines in the international community. On today's Upfront, we discuss the significance of this right and ongoing controversies.
People are now living in the era of the huge internet world as well as the digital society. And it has enabled people to search any kind of information, including the personal data on the internet. However, violation of privacy, defamation, and exposure of personal data have become serious social issues. And as information on the internet is easy to be spread and also difficult to delete, there have been many cases of unwanted exposure of private information and online witch hunts. Accordingly, there has been a growing significance of the right to be forgotten, which refers to the right of individuals to request their personal information be removed from the internet. Right to be forgotten has become a controversial issue after a case of the European Court of Justice in 2014. The court ruled in favor of a Spanish man who had sought the deletion of an article that appeared on Google and newspaper pages, which was related to his old debt problems that happened 12 years ago. After that case, Google has received about 220,000 requests over a year to have personal details removed from its search engine. Along with the rising significance of the right to be forgotten within the global society, Korea has also taken its first step by releasing guidance on the right to be forgotten. According to the released guidelines, people can request website administrators and search engine operators to remove certain digital content of personal information. Upfront discusses the significance of the right to be forgotten and the remaining challenges.
To help us navigate through today's issue, we're joined by Attorney Kim Sung-youl, President of Korean Patent Bar Association. And also, we're joined by Professor Park Kyung-sin, Professor of Korea University Law School. Thank you for joining us.
Thank you.
Thank you.
Now, let's start with the definition itself. Professor Park, help us understand what is this right to be forgotten. I guess you can request the data providers to delete some of the information that you have provided or the personal information.
To understand right to be forgotten, we need to have a couple of definitions down. The distinction between personal information and the information that you created has to be made. So what the Korean government just adopted is not about personal information, which is information about you, but it's about information that you created. So the discussion about right to be forgotten overseas actually doesn't apply to what Korean government just adopted. It requires the providers to delete the information that you created, regardless whether it's about you. Now, the overseas discourse on right to be forgotten focuses on whether you can delete or delist the information about you, the information that you did not create.
I see.
Yes.
But then when we talk about the right to be forgotten, then we're talking about the information that you have created, but in terms of who created that.
Right. So there are like three different versions. The European discourse. In European discourse, right to be forgotten is about right to delist the information about you from the search results, the results of a search using your name as the keyword. Now, the right to be forgotten that the Korean government that just adopted does not give you the right to delete the information about you, but give you the right to delete the information that you created in a certain service. Now, if you are shrewd, you will know that you already have the right to delete the information you created a lot of times,
right.
as long as you have your ID and password ready. So there is a bit of a confusion about exactly what was just adopted by the Korean government.
I see. I hope that because we have to both talk about both situations, I hope through the discussion it becomes more clear. Mr. Kim, but how difficult is it to delete your own information from the net? I guess you could, as Professor Park mentioned, you can request the portal site if you have created some information, or is there some falsified information that I guess you could request it to be deleted?
As for the deletion process, it's like three categories. One is his own post, and the second category, repost or original post.
Right.
And the second, the third parties posts. And the first one is just his own the poster, unless there is other third parties interest involved, then maybe it can be solved by bilateral actions between the search engine and the internet consumer or user. And the second one, repost, maybe is a little different. Maybe repost was incorporated in another website.
Right.
Then the third party is interested involved, and therefore we should get some kind of consent from them. Otherwise, maybe we need some kind of legal ground. Also, as for the third parties posts about for example, my own personal informations, then maybe there is a need some kind of legal ground for such a post to be deleted. Otherwise, it will be possible. It will not be possible. And therefore, I think therefore is like the right to be forgotten has been enacted in Europe.
To cover that area.
Yes.
Right. Okay, I guess this is a good time to talk about the case that made a lot of controversies. Maybe this is why we're talking about it in the first place. There is a landmark case in 2014. A European Court of Justice upheld a complaint. I think Professor Park mentioned that this case a little bit, Kosteha case. He had discovered that the Google can search his past debt problems. So he requested the data provider to delete it, and it became a court case. And the court upheld the right to be forgotten and called for Google to amend the results on the request. Now, this has made a lot of headlines. Now, going back to Professor Park, why did this case make such a splash in that particular topic?
Oh, well, because it requires Google to suppress completely lawful information. Basically, the information about where it's like meta information. The information about information. So the information about where newspaper advertisement about auction of lawyer Kosteha's house is located, the URLs, because it requires Google to suppress the URL information of that data. Now, it's publicly lawful information, so it has nothing to do with prevailing notions of privacy. And it requires Google to suppress the information for reason that it is quote unquote no longer relevant because lawyer Kosteha is now a successful businessman.
Right.
Now, it is really mind-boggling to a lot of people because so lawyer Kosteha could request could make that request because now he has become a successful businessman. Because he believes that his past financial difficulty is irrelevant to his present. But for a lot of people, his past will be relevant information.
I see.
And what relevance that people can find in others' past is really decided by other people looking for that information. For instance, a researcher on judicial reform of Spain may want to cross-index his name because he's a lawyer with public auction data to find whether lawyers in that region have financial difficulties. And this, the decision basically required the suppression of completely lawful publicly information for reason that the data subject, lawyer Costeja, finds that past, the information about the past, irrelevant. But who is to decide, right? I mean, when you say relevant, you never say something is relevant. You always say something is relevant to X or Y, right? Now, the information about his past auction may not be relevant to his control of self-image, right? But it may be very relevant to other people. And you talk about controlling your image. Who owns your image? I mean, where is your image? Is it in my brain? Is it in my
guess
body?
you come
No.
from-
Other people have your image, right?
Maybe it's a freedom of press kind of issues, but also Professor Park and I myself included, from a researcher's or academic's point of view, more information is always better than less for even the public goods purposes.
As long as it's lawful information, it should be made available.
Right, but I guess you might have a little bit of different perspective. What's your significance? What do you see the significance of the Costa case?
As Professor Parr already mentioned about some kind of balance. I think this is a crucial issue, striking a balance between the privacy right and free speech. That is very important. But maybe I think the legal system is a little different. The continental laws, like as I mentioned before, is a very broad view on the privacy right. And also definition of defamations. In Korea, it's like, even if it's a true fact, some kind of defames others by alleging the true fact, can be defamation, can be constituted defamation. In this case, and therefore we should be careful in the definition of, or just the interpretation of some kind of link, such. It's like originally, the bad financial condition was appeared in the local newspaper, and the second stage is like it was Google decide these articles will be retrieved and fall into the scope of the searches, and then just it's how can I say, intentional act is involved, such as the linker, and then move into appeared in the search result.
Right.
And therefore, it's like currently is on the internet world and digital age, I think public display of the personal informations by the search link is very enormous. And therefore, this kind of things, link is a kind of separate and independent actor. Originally, therefore, the European Court of Justice that says newspapers article is okay. It's a kind under the press exemption doctrine. It's a public. But this stage is a little different.
I see.
A kind of separate and independent activities. And also, just like Google, search engines have some kind of discretions in determination whether or not which materials will be retrieved or linked. And they just arbitrarily discretions they exercise. And then they kind of thing subject to the judicial review. And then say, just as you may be aware, continental law is legal terminology is very vague, which covers all the cases. But it can be
sometimes
concreted.
Intentionally.
It's by the case, case bias. Irrelevancy is very vague concepts, but it can be determined by the Google itself. Google decisions will be subject to judicial review under the strict scrutiny theories. And therefore, in this case, for example, if, for example, his previous bad credit record, for example, under the California law, after 7 years, the credit information will be deleted upon the request of the credit holder. And in the same context, same token, just the European Court of Justice said, yeah, this is not relevant. It's no longer appropriate, and therefore it should be deleted.
Right.
Yeah, the link should be deleted, and therefore we should find out the good logic for such a court decision.
Let's move on. We'll now take an in-depth analysis, which we already embarked on the major controversies surrounding this right to be forgotten and also the remaining challenges. But before that, let's take a look at a short video footage.
Public opinions have been sharply divided on the right to be forgotten.
I might not feel comfortable with the fact that someone else might have access to my personal information, which I want to remove. So I think we should have the right to be forgotten.
I'm not sure about introducing the right to be forgotten, as critical information might also be removed.
Controversies have been raised over the protection of privacy and invasion of society's right to know. People who support the right to be forgotten have criticized the fact that individuals don't have the right to remove data or links from the internet, even if they are related to their personal information. In that sense, people can encounter disadvantage because of the unwanted posts on the internet when they try to get married or find jobs. On the other hand, people who oppose the right to be forgotten have said that if any kind of information can be erased by the requests of the individuals, it might be a serious violation of the society's right to be informed, which is one of the most significant and basic human rights, and it can also lead to the distortion of information. All eyes are now on the impact of the newly implemented guidance on the right to be forgotten when it comes to tackling the ongoing controversies.
I think it's eminently clear which position you experts take. Now, let's take a little bit of debate format further. Let me start with Professor Park. Let me kind of challenge you a little bit. But isn't it a good thing to have a protection, though? Because we have seen in Korea a lot of instances where the false rumors or groundless postings retweeted and reposted all over the place has caused the umpteenth degree of pain to not only the celebrities, but also ordinary private citizens as well. So isn't there a kind of a ground or the assertions that people can make that there needs to be a protection?
Well, if it's groundless, if it's defamatory and false, we already have a defamation law that punishes people who post groundless rumors. On top of that, we also have a law that forces the service providers to take down the information temporarily, even if it is lawful, even if it's not defamatory, even if it's not privacy infringing. Section 44-2 of Information Network Act requires service providers to do that exactly. Basically, if anyone finds something, if anyone claims some posting to be defamatory or privacy infringing to him or her, the hosting, the company hosting the information is required to take that down up to 30 days. Because of that, a lot of lawful information are being taken down already. I don't know whether you remember, there was a hospital where nurses and doctors did a birthday party inside the operating room and
Right.
posted pictures of the birthday party on the internet. The hospital apologized, blah blah blah. But in the background, they were deleting all the postings that were criticizing the hospital.
I see.
It is, and it's the photos that they themselves uploaded, so it has nothing to do with the privacy, at least not the hospital's privacy. It's not defamatory because it was true, and it was to the public interest because it concerned the safety within the hospital. The cases like that abound in Korea. So I don't think we need the right to be forgotten.
But
on top of
is that the point? If you have the right to post it, but shouldn't you have the right to delete it as well? I guess it's a kind
Sure.
of a freedom
Sure.
aspect to it.
That I agree. So that's why at the beginning of the show, I made a distinction between information about you, information that other people posted about you should be protected because it's their posting. But the posting that the posting that you made about you or other people, well, you own it in the relationship with the content host. So as long as you keep your ID and password, you should be able to delete it. If you lose your ID and password, most portals have ways of identifying you and retrieving the lost ID and password. So that should be protected. I have no opposition to that. Now, there is a bit of issue about kind of a wiki type of portal where you put up a question and other people added answers.
Right.
And if you are allowed to take away your question, then all the answers that other people provided become meaningless. So it kind of harms not just the content host, but it harms the people who have contributed to the discourse. But other than that narrow example, I don't oppose, protecting consumers who have lost their ID and password so they cannot remove their own posting.
I see. Do you have a response, or do you have a different kind of scope of the protection from what Professor Park is saying?
Yeah, basically, I fully understand the Professor Park's positions. Yeah, I think free speech is very valuable public interest and to fully protected. But I think this. But anyhow, just we should know the rehabilitation process. For example, like as I mentioned before, he just committed criminal activities, and he put into imprisonment for certain times. After served his imprisonment, then also he have a chance for the rehabilitations, and also according to current Korean criminal laws, like criminal record will be deleted, and it can be also applied to on internet world, and therefore it's like and the Korean law is like the relevant law is like intellectual property law, and also information and the communication network law. Actor, and also personal information protection act. Yeah, all of them is like they just as I mentioned before, just the defamatory statement or some kind of invasion on the privacy right will be just blocked out or just be deleted upon the request of the internet users. But I think, how about some kind of inflammatory, so unpleasant as a previous past record? But it's objectively it's not serious, but it's subjectively it's very serious. Then, certain circumstances, I think the rehabilitation process is guaranteed. Otherwise, maybe just, for example, I'm just maybe just evaluated as a racist. Racial discrimination. For example, in the 30 years when I was young, now it's like 50 or 60s. Like still, it's like the record is like belongs to me. It's very too harsh, and therefore, in this case, for example, Gonzalez case says all kind of his bad financial condition was around several years ago, and therefore the court decided it is relevant, no longer inappropriate, no longer appropriate, and therefore the link should be removed. Right. And in the same context, I think, for example, like very bad past records, maybe best, maybe two things is guaranteed. If we guarantee two things, I think it's maybe it cannot. It's just maybe just. Infringe some kind of free speech right. For example, like more reasonable standard for deletion. And also some kind of transparency of a deletion process. And for example, it's like, sorry about that. It's like deletions, like record is preserved, for example. Then I think, and also some kind of
I see your point, but let me challenge you this time. I think you mentioned a very appropriate example. There's a rehabilitation purposes, and probably that's what society wants to a certain extent. But what about the public's right to know? If somebody has a criminal record, isn't that in some ways in the public goods, or in some ways necessary for the public to find out? And I guess I'm talking about the misuse possibility of the protection right.
But it's, for example, like original according to the European Court of Justice decisions, like they said the original document was not touched. Only just the linker was removed. They ordered linker should be removed, and the original document can be found out.
Right.
And in any way.
Yeah, but how do people find it?
In such case, maybe if we just preserve, maybe we just establish some kind of regulations for the transparency or to ensure the transparency of the deletion process. And then they just, if they delete some kind of post, then they just reserve the such information in certain area. And also later on, limited circumstances, and it will be open. And also, if such kind of information, deletion record is accessible to the limited number of persons. Maybe possible is like just approval of the court. Then maybe I think this kind of problem will be resolved. And therefore, I think, I understand your positions, like the court decisions, like maybe some have some possibly pose some problems, but maybe some kind is in a certain circumstance it is modified. Then I think we just striking the balance between the.
How about this? This is a solution to kind of, rather than the free reign, there is a carefully prescribed process.
Sure, and that's what Google is trying to do, and that's what the search engines are trying to do. They are notifying all the websites which of the postings in those websites are being delisted from the search results, so that those websites can list whose names are being, the search results of whose names are being manipulated or edited. But the European regulators don't like that either, for good reason. Because if each website has a list of names of people who have, submitted right to be forgotten requests, they'll become famous because of, for that reason. A lot of people will look at the list first, trying to find out, who has tried to manipulate what search results I'm seeing, right? So that just defeats the purpose of right to be forgotten. And I think it's a purpose that's impossible to achieve. I support rehabilitation. There are two ways of guaranteeing rehabilitation. One is by combating unreasonable discrimination of people for their frivolous past wrongs. So we can have strong anti-discrimination law so that people don't lose jobs for having committed petty crimes in the past. The other way of doing it is blinding ourselves to our own past wrongs, like suppressing the information. But if you do that, you don't give others fair chance to protect themselves.
I see.
There may be people who don't want to do business with others who have failed to pay their Social Security debts, right? There may be people who people who are sticklers about who to do business with and who to vote for, and they may find it completely relevant, other people's criminal records. Now, I don't oppose these laws, these rehabilitation laws that expunge, bad credit information or bad criminal information from the official records. But what if there are people who, in the past have found out valuable information about others, like, that this person did not pay the workers the wages,
right,
or has committed, some, sexual harassment against students, things like that. How about those people who have access to that information? Should we, shut them up? Should we really suppress access to that valuable information just so that the wrongdoers are
right,
protected from discrimination?
Yeah. I
the
think
better way to achieve rehabilitation is by combating discrimination itself, not combating information.
Both gentlemen has passionately advocated, which I think that a lot of people agree that the society needs both elements to it,
yes,
freedom and rehabilitation. This is a good time to bring in the person who is really leading it. Individuals in Korea now have a right to request the access restrictions on personal internet postings. We have a chance to meet Choi Sung-jun, chairman of Korea Communications Commission, a government ministry that has taken a leading role in introducing a right to be forgotten by releasing the guidelines that we just talked about, which is in force in June.
원래 문제가 된 이칠 권리라는 것이 기본적으로 사생활 침해나 명예훼손인 부분도 있지만 그렇지 않더라도 즉 과거에는 아무런 문제가 없는 적법한 게시물이었는데 일정한 시간이 흐른 다음에 그 게시물이 꼭 그 검색이 돼야 되는지 하는 그런 필요성의 문제가 생기게 됩니다. 그래서 그런 경우에 이칠 권리가 더 의미를 갖게 되는 것인데 그것은 또 반면에 어떤 문제가 있냐 하면 그런 것을 다 삭제를 해주다가 보면은 뭐 표현의 자유라든지 언론의 자유라든지 국민의 알 권리라든지 이런 게 또 침해된다는 그런 다양한 의견이 지금 서로 대립이 되고 있습니다. 그러다 보니까는 외국에서도 그 이칠 권리를 어떻게 법제화할지에 대해서는 굉장히 다양한 논의가 있고 아직 해결 방안을 못 찾고 있습니다. 우리나라도 아직 그런 사회적인 합의가 안 이루어지고 있지만 저희들이 생각해낸 것은 그런 표현의 자유, 알 권리와 저촉되지 않으면서도 우리 그 이용자들이 그로 인해서 불편함을 겪는 부분이 없을까? 뭐 많은 보도가 됐습니다마는 결혼, 그 다음에 뭐 취직, 승진할 때 과거에 그 사람이 올린 게시물의 내용이 어떤 건지 분석을 해가지고 그게 문제가 됐다는 사례도 있지 않습니까? 그래서 그렇다면 그런 부분은 자기가 올린 게시물이기 때문에 뭐 표현의 자유 문제라든지 국민의 알 권리라든지 이런 게 거의 문제가 안 돼서 우선 자기가 올린 게시물에 대해서 스스로 접근 배제 요청을 할 수 있는 것은 가이드라인으로 해가지고 시행을 하면 그런 사회적인 논란도 별로 없을 뿐만 아니라 또 이용자들한테는 실질적으로 많은 도움이 되겠다 싶어가지고 먼저 그 부분을 가이드라인으로 만들게 된 것입니다. 그러니까 제3자 게시물 중에서 명예훼손이나 사생활 침해가 되어 있는 부분은 지금 현행 정보통신망법 44조의 2에서 그 부분에 대한 그 해결 방안을 지금 이미 규정을 하고 있습니다. 그 규정에 의하면 그런 사생활 침해나 명예훼손 등 권리 침해를 당한 사람의 경우에는 정보통신 제공 서비스 사업자에게 자기가 그와 같은 침해를 입었다는 사실을 소명을 해가지고 그 게시물에 삭제를 요청을 할 수가 있고 그 부분은 저희가 그 완전히 배제를 한 것이 아니고 앞으로도 지금 계속 노력을 하면서 이제 전체적인 사회적 합의가 이루어진다면 그 다음 조치로 더 나갈 그런 계획도 가지고 있습니다. 게시판 관리자나 또는 그 포털사한테 나름대로의 그 판단 권한을 줘놨습니다. 물론 그 회원으로 탈퇴한 이후에는 그 개인정보를 못 갖고 있기 때문에 과연 이 글이 과거에 이 회원이 올린 글인지 탈퇴한 사람이 올린 글인지를 확인해 보는 게 쉽지는 않을 겁니다. 그렇지만은 그 근래에 있는 그 다양한 내용들과 그 다음에 이 지금 그 접근 배제 요청하는 사람이 이게 자기 글이라고 나름대로 연결고리를 찾아가지고 입증을 하려고 할 겁니다. 그래서 그 입증이 제대로 잘 이루어진다면 그러면은 이제 삭제가 가능한 것이고 그 게시판 관리자나 그 검색 서비스 사업자가 판단해가지고 이거는 그 게시물 본인이 올린 게시물인지 잘 모르겠다. 그러면 그 경우에는 그냥 그거를 접근 배제 요청을 거부할 수가 있습니다. 그렇기 때문에 저희가 보기에는 뭐 그런 악용의 문제가 크게 생기지는 않을 것 같고요. 게시판 관리자나 검색 서비스 사업자 입장에서는 그 더 많은 자료를 갖고 있기를 원하겠죠. 그런데 뭐 처음에는 그 약간의 오해도 좀 있었고 그랬는데 저희가 여러 번 그 사업자들하고 만나서 서로 문제점에 대한 그 설명도 열심히 해드리고 그 다음에 설득을 해가지고 지금 제가 알고 있기로는 그런 부분에 대한 오해는 이제 다 풀린 걸로 알고 있습니다. 그렇기 때문에 인터넷 기업들도 지금 이제 준비를 해가지고 뭐 가능하면 6월 중에 빨리 이런 조치를 이제 실시를 하려고 생각을 하고 있는 것으로 알고 있습니다. 처음 있는 일이고 그 다음에 앞으로 벌어질 상황에 대해서 저희가 나름대로 다 예상을 했지만 또 그 미처 저희들이 예상을 벗어나는 그런 일들도 생길 여지가 있습니다. 그래서 우선 가이드라인으로 만들어 놓으면 그런 일이 벌어지더라도 그때그때 맞게 가이드라인을 수정을 해가지고 좀 더 정치하게 이렇게 만들어 나갈 계획이고요. 만약에 그게 어느 정도 수준에 올랐다고 생각이 되면 뭐 그 법제화도 필요하다고 생각을 합니다. 그리고 뭐 법제화의 방향이라는 거는 아까 말씀드렸던 것처럼 이거의 가장 큰 핵심은 그 개인의 자기 게시물 관리권이기 때문에 그 자기 게시물 관리권이 잘 보장될 수 있는 방향으로 그렇게 법제화를 해나가도록 하겠습니다.
Now, with this guideline, probably we can make some distinction as to how we are different from maybe approaches from European Union and also Japanese case.
Yes. The KCC chairman described this guideline as right to be forgotten, but it's not. Right to be forgotten is about restricting other people's right to talk about you, but what cases adopted does not restrict other people's right to talk about you. Mm-hmm. It only concerns your ability to withdraw what you have posted in the past. Mm-hmm. And it does not even concern reposting of what you have posted, like reposting right. At other service of what you have posted at your service. Mm-hmm. So it is confusing to a lot of people what the guideline is supposed to achieve, because most users of content host already can retrieve their lost ID and password to make sure that they can delete whatever they posted. Mm-hmm.
If you know the ID and password that you have,
and even if you have forgotten, if you submit special request, the portals allow you to reset find the ID and reset the password. Mm-hmm. So it's like a consumer protection, not data protection, that has been guaranteed. So many people complain that calling this right to be forgotten is not just confusing, but it's giving people false. It's falsely making people comfortable with the idea of right to be forgotten by calling it right to be forgotten. We already have truth defamation law, which restricts people's right to talk about truth about others. We already have Network Act mandatory takedown law, which allows people to take down other people's postings just by claiming that the postings are defamatory or privacy infringing.
Right.
So we have enough laws restricting people's right to talk about other people. We don't need another confusing guideline that makes people believe that they can take down more of what other people have posted.
Mr. Kim, I don't ask you to defend the guidelines, but as mentioned, the omission of the third-party postings in this, is this crucial? What do you think this guidelines
Yeah,
will
but
do in that regard?
that is a very crucial, and also that is a very controversial issues all over the world. And therefore, just the KCC should find out the solutions to establish the guideline. But in absence of underlying the act, the guideline itself does not have that much, does not have meanings. And therefore, but anyhow, just whether or not we should decide. As for the third-party post, we should grant some kind of right to be forgotten to the internet users. And that is very important matters, but it takes, I think it takes time. We need some kind of social discussions and research, and which will result in the social consensus about whether or not it will be enacted. It will be enacted or not. But anyhow, just this guideline, there's some kind of some merits. I think there's some kind of process. For example, even if it's limited to the poster's own posture, but some people say there's blindness, like, and they put some signs, and someone just this is my own poster. He claiming that, then just they kind of they required some certain notification process, and therefore it's like a kind of accuracy or the kind of the reasonableness of the deletion process is a little secured in these guidelines. That is, I think, have merits. But the most important thing is like just the guideline. Maybe just I think is in this guideline does not cover the third party's poster. That should be supplemented.
From the case's point of view, they did mention that this is a starting point of their endeavor. So it seems like they're leaving some room that this could be improved or maybe amended later on. But going to a little bit of difficulties, I mean, you mentioned that you can delete your own postings under this, but if it's not the matter of just forgetting your ID or password, but if you as actively got out of the service, if you deleted your information, and current law requires the service providers to delete your personal information after a certain period of time, then if you go back and in order try to delete it, how would they ascertain, or how would you make sure that it's you that you're requesting your own deletion?
Well, I think that's one of the reasons that although this guideline is fairly limited in restricting information flow, companies still resist that because the Constitutional Court struck down the real name information law back in 2012, and a successive amendments to personal data protection law prohibited the content host from retaining personal data. Without personal identification data, it's really difficult for the content host to really find out whether the person who came back to the company after several years is really the person who made the posting. I think that it's something that the companies have to make best efforts in.
I see.
In the way of, for the spirit of protecting consumers.
Right.
But then again, I mean, who is the consumer, right? Who is the person that they should protect? So it really becomes it really becomes a dilemma. Because yes, you want to protect your consumer, but you don't know whether this person requesting deletion is one of the consumers, right?
That seems to be one of the difficulties.
Yes.
Mr. Kim, I'm curious as to what the IT sector is thinking about this. For example, I mean, the IT companies could have a reaction to it, but also, for example, the small businesses that uses this maybe the small shopping malls, and they have this marketing strategies where they pay people by points or some rewards to post their reviews of a product or the services. And would that be a situation where if you pay for the posting, it seems like the posting is no longer the owner should have the ownership of the poster.
Right.
So there might be a situation where you post it and get the reward, and you want to retract your review. That might not be a good thing for the small businesses.
I think the latter questions easily resolved by the legal principle of the current laws, because you already get reward for the providing the review on internet, and therefore I think legally it can be it cannot be belong to the original poster anymore. Maybe a third party's interest involved, and also there's such kind of things is within the foreseeable the scope or foreseeable risk. Scope of foreseeable, and also maybe just that kind of assumed risks, and therefore I think the right to be forgotten will not be applied to such kind of persons. Maybe they should obtain some kind of consent from the small business owners, and then it's possible. And also in the IT sectors, like they are very is against the adoption of the legal right so-called the right to be forgotten, because it's a very it's like a burdensome, so hundreds of thousands requests and they solved, and therefore they should be keep the personnel and the facilities and also budget, etc. And also it's a very burdensome. Also, they just maybe they assumed some kind of role as the censor-in-chief. This means like he exercised some kind of discretion whether or not such a request should be accepted or not. In such case, they have some kind of some negligence are involved. Then they are subject to liabilities.
Right.
And therefore, it's like a kind of increase of the litigation, etc.
Now, that's another difficulty. But even if this is implemented as intended by the guidelines, but is there an issue that this only subjects Korean companies to the standard? How about the companies coming from overseas, which has their service overseas, so arguably they may not be subject to the Korean laws?
Yes, it makes it more difficult for Korean companies to run their business in competition with foreign companies that are not subject to the same guideline. I mean, one of the difficulties with the guideline is it's difficult to figure out what the purpose is or what the protected legal interest is. Is it copyright, right? Is it right to control your own work, your own posting? Or is it right to your personality, like, right not to be defamed, right not to be blah blah blah. Because if it's about it's about copyright or right to control your own posting, as he said, if you receive some points for having having made some postings, then you have lost a right to control those postings.
Right.
So you should not be able to delete them any longer. With that understanding, many IT companies have flourished overseas and domestically. And if those transactions, those exchanges between the points and postings are not recognized, are allowed to be withdrawn a few years later, then it's really difficult to run businesses. And yes, I think that's why Korean companies are calling it reverse discrimination.
I see. We're almost out of time, but I'll give you 1 minute each to offer some advices as to future directions, beginning with Mr. Kim.
Yeah. First of all, just emotionally, everybody is more sympathy with the recognition of the right to be forgotten. But as it applied, especially America is more reluctant to adoption of the right, this right. But anyhow, just we are facing, right now, internet world and digital age. And we are just manipulation of the big brother, which is a search engine, such as Google. As I mentioned before, in the selection stage, which materials will be linked or searchable, then there might be some kind of arbitrary decision-making process involved. We are just all about that matters. And also, therefore, we should, this kind of right should be granted as a human right and also digital consumer right as well. And also, it's an offline world, like rehabilitation process is well established. Same logic will be applied internet world.
Okay. And you have the last word.
I think calling the internet big brother is really unfair, because it is through the internet that people can watch and monitor what big brothers do. By allowing people to share information about what the government does, what the big corporations do, and what the powerful people do, we have democracy. By allowing people to freely exchange information amongst themselves, we have efficiently functioning market economy. The internet has contributed to that, and now calling it big brother and trying to countless individuals, trying to restrict countless individuals' ability to get more information about one another will, I think, backfire. With this government, with this Korean government guideline, I don't know whether to laugh or cry, because it has nothing, it has no restriction about that. It has no restriction like the European type of right to be forgotten, restricting other people's right to talk about us. But KCC also, so on that, I'm happy. But then again, KCC says this is only a start. So I'm worried that people may take false comfort and just believe that right to be forgotten is already here. So we just accept whatever restrictions imposed upon us on our right to talk about others.
A lot of work is to be done ahead. Thank you for your contribution today. The balance between the right to be forgotten and the public's right to know, not to mention the complexity of the implementation, even if we come to a choice as a society, is delicate and controversial. As Korean society grapples with the digital landscape, any decision we make must be through much debate about who we are as citizens on and off the net. I hope this discussion has contributed to the effort. Thank you for watching. I'll see you next time.